Hey, Linnea.
Hey, how you doing?
I'm good. How are you?
Doing great. Just finishing up the dishes from lunch. And
Oh,
Yo, yo, yiggity, yo.
what's up? What's up,
hey,
broski?
What's good with y'all? If I can say real quick before you open, I unapologetically sent that to you and Adam. I'm pretty sure you know why, because you saw who it is. However, I'm open for correction because I thought I went above and beyond over these last couple of years. And granted, I know things have changed since we've done things as far as how things are going with Mortgage Free 2.0 or whatever. But yeah, I've that's one of the friends-in-law who I think, because I am an elder lady, you should take.
Stop it.
I don't like that.
I just want you to know we're live on TikTok.
Don't take. I don't want nobody taking advantage though. Like, hey, I'm gonna keep it a buck. I don't think we
I
should be
already
taking
know what's
advantage of
up,
that.
bro. Let me just
Yeah.
say, I already know what's
Okay.
up.
All right. I yield.
I don't know if you heard Adam.
Well, no. What would he say? What bro say?
Hey, good day, bro. Good day.
What's good with you, broski?
Oh,
He
I'm
didn't
well.
actually say anything, but
I just laughed. I just laughed. We all good.
Okay, indeed. I know, but I know I'm always, it's like I'm the asshole of lawful living, I guess.
somebody
not
got
at
to be bad
all.
cop. No, it's okay, Hassan. It's okay. Somebody has to be bad cop.
Let our
I'm,
friends-in-law in, guys.
indeed.
Gratitude for dropping the daily heart me when you guys come in the room. Greetings, friends-in-law. Greetings. Welcome in. Peace from beyond the ocean or the Bar Association.
Wow.
You already know that's freedom. The
That is hilarious, actually.
with the foolishness. That is too funny. So let's make sure. Okay, so our recording is going. So welcome in, everyone. Welcome to today's live. Great day to each and every one of you. We appreciate you guys being here. Some of you joining us for the first time today, and some of you are joining us for the sixth or seventh year. And most people are somewhere in between. So we today is allegedly there.
Yeah. Yeah.
Allegedly the 21st day of the month of April in the fake year of 2026. And we're gathered here today on where I hope it's beautiful where you guys are, whether it's raining or it's shining, uh, for our Newbie Tuesdays. One of the things I like about Newbie Tuesdays is that it reminds us that we can all learn something and it could literally be from anyone.
Word.
It might
Forever a newbie.
it might be something that we like or something that we don't like. It could be taught to us by someone we look up to or someone we look down upon.
Right? You never know who you can learn from.
You could learn from someone younger. You might learn from someone elder. Okay, you might learn from someone that's here in our physical realm or someone that has never been here or passed on. But as long as you s remain skeptical of even what you might believe now, You will be all right. Something about taxes got the case dismissed. Taxes got the case dismissed. Yeah, I guess we could yell out all the newbie phrases at the same time, right? Those thoughts, people think that they're advanced. Statements, thoughts like everything is a tax assessment. Every case is a tax assessment, or everything is about taxes, and all cases are trusts. Anybody ever heard those types of things?
Be careful, you're touching a soft spot.
And that's what we're here to do every Tuesday. Touch
Word.
those soft spots. Gratitude for the gift, guys. Yes, y'all heard assessing the taxes got the case dismissed. And people purport those things as if they're advanced, don't they?
I'm not even sure what that even means, like procedurally.
Yeah, it
Assessing
sounds
the tax.
bad
Do I
when
do
you
I put
say
in a
it.
motion to assess the taxes? I don't know.
It doesn't matter what it means. It's provocative and it gets the people going. Let me stop.
That's basically the bottom line. Is it not? My trust got the case dismissed. I was operating in equity. I invoked exclusive equity.
Oh my gosh, please watch that video, y'all. The exclusive equity video. Shout out.
Gratitude. Today's, and I know Trey Brigade is here, but today is my last one. It's the last one I'm clarifying and debunking. It is the Sedekay vibe myth.
what,
Yes, this like the
what, we
final
got, what
episode.
we're gonna be talking about it today, brother?
Huh?
What we're gonna be talking about it today? I'm ready. I'm in. I'm in. I'm fully in.
Yeah, I just saying I did the video. I'm like, I think the people need to see this one too, and then I'm gonna let go. I'm gonna stop debunking
The newbie
uh
stuff.
the sovereign citizen myths. Let's call it that. The
Mm.
sovereign citizen myths, I guess. I'll leave it alone.
It's my religious right to get the case dismissed. That's right, Godly. Let them know. It's against my religion to be held responsible for the shit I did. Anybody know what I'm talking about?
Word.
Hey, Mrs. Credit Pro. That's who you gotta call. Yes, give me your W-9. When our friend-in-law started with that. We say things like that with our whole chest as if we can find any linkage, even if you want to say in timeline. So some of you guys may know what I'm talking about that are not so new to our lawful living community, that
Word.
there are things that are not on the record, okay? That are we going to say contributing or controlling a case being halted, dismissed, enjoined indefinitely? How are we going to say it? There are things that are not on. There are things that are not on a court record.
Wow. I got it.
Anybody know what I'm talking about?
Yep.
There are things that are not on a court record. I'm wearing my Beat the Bar shirt in case you guys haven't noticed. Making sure I flip my camera on TikTok so everybody could read it the right way. Beat the bar. Somebody asked, well, why do you write it that way? Of course, they're an attorney. They want me to say some other newbie shit like British accreditation registry or something. But I don't claim to know what this means, actually. But y'all know who I'm talking about, right?
They know that attorney knew who you were talking about.
Yeah, I'm talking about
Sound
you,
like you want
bitch.
smoke.
I don't care what this stand for. I'm just here to do this part. Y'all see that part?
Word.
Because when it really comes down to obfuscation, right? These are the experts. And I can't get over the fact that it has been revealed that they don't learn the First Amendment.
You know I'm laughing, right?
You could tell everybody why you're laughing.
Nah, I'm just gonna keep that private. I'm not gonna mix the public with the private and the privates and the publics. Let me stop. Let me stop.
And definitely don't take your privates into publics.
I know, right? I know, right?
Ew. You
Jesus
nasty.
Christ. Sheesh.
Vidal says, I call BS alert. What? You don't want to use your trust to get the case dismissed in equity? You're going to flip the court.
Exclusive equity.
You're going to flip it. How many people find themselves frustrated that their constitutional arguments are not being recognized as legitimate?
I find it extremely frustrating.
Same. Y'all got
Like,
one thing to follow and y'all can't follow that. Why?
why? Why do
What
y'all,
what what
why
what
do you,
what is this that they got to follow in there?
To guard my constitutionally protected right.
Okay,
That's
okay.
all they need to do. That's it.
Got you, got you, got you. I can appreciate that because I thought it was something else that you were gonna say. Yeah,
To
I
which
thought
they
it,
took an oath.
yeah, well, I
say that
thought it
again,
was something
Aga?
else.
I'm sorry, I just was saying to which they took an oath.
Okay.
But what happened here, not to divert, and it's something that maybe we should think on to answer. Just from our own intelligence, wherever we are, which branch of government it appears possess the most dominant power, if any at all? Just for in your own opinion. Just looking at the structure of government, their acts and their omission, which branch of the three government appears to anyone that has this most dominant powers?
I would say
I would
executive.
say the judiciary.
Huh? Hold on, hold on. You
Put
could
it,
type it in the chat.
y'all can
Maybe you
type
should type
it.
it. Yes,
Y'all can
type it in.
say it.
Yes.
Let's type it in so we can see. Okay. We got 2 for executive, 1 for judiciary, 1 for legislative. Which one, guys? Put it in. Executive, legislative,
And
executive.
the question is who appears
Yeah, of
to
course,
have
because
the most power. Okay.
they're supposed to be triune, right?
Right.
One is not supposed to be more powerful, and then of course the others are not supposed to exercise authority that has been explicitly or even implicitly for another branch.
All right. What do we have here though? At least maybe it's gonna be sorry.
What was
Maybe
that
it's
to leave? Okay, maybe. Talib, were you speaking to us? All right, carry on trading.
no, I'm looking through, but I was saying maybe it should be what you call hold in unlawful living.
A pull on,
The
okay.
question, yeah, the question
Yeah.
because I find it interesting that most people may be saying the executive.
Yes, most people seem to be saying executive.
Here is saying the executive, and I think more people could have answered, right?
And I was saying that the word appears, like Linnea said, is the optimal word in your question.
Yeah,
So,
because when I say appear, I'm speaking from the standpoint of having studied or not.
Well, I've been a sheriff.
In your own comprehension, you know?
I've been a sheriff in North Carolina for 15 years, and the branch that I think is the strongest is the Constitution of the United States of America. Let me stop.
What are the executive doing shit?
Many of the
It's the
people who
executive.
voted for that sheriff and who vote for sheriffs and other officers of the executive branch
Yeah. So,
are on that same level.
yeah, yeah,
Okay.
yeah. I tend to think we undermine the what you call it, the judicial branch in many aspects, you know? The
I call,
judicial branch might see most people did not even type the judicial branch, and I think we
That's
under
who came to mind for me, just being
yeah
honest.
yes,
What came to
yes,
mind for me is the judiciary
yes, the
because the
judiciary.
other two branches seem to default to the judiciary, which is what makes the post New Deal offense even more offensive to my conscience.
I've always said the judiciary is the laziest branch because nothing gets done unless it's challenged through the judiciary branch. Most people just acquiesce to the legislation and the executive.
And they administrate through to the executive officers that do nothing. And the executive officers is like, oh well, unless the judiciary tells me something, I ain't doing shit. And then we're over here like, I don't want to start a court case.
Exactly. When that's where we have to execute the most power of we the people through the court.
I
Y'all
agree
like my
with you.
fancy bracelet? I'm flexing on y'all like a mere law.
That's funny.
No, your teeth seem to be in good order.
Nah, don't do that, bro. Don't do that.
Come on, bad cop.
So yeah, so the judiciary is has been stuck in deference, right?
Yes.
And they are deferring to the executive,
Yes.
but it's also a controlling mechanism by their silence. What they decide not to correct the executive branch on. What do you guys think about that?
I think we should. Can we order in bulk judicial disability complaints? Because that's what it sounds like. It sounds like, oh, my job is to interpret. It's okay. I'm just going to defer.
I would love that more than anything. If we could do like batch or like hotline or, group
Well, here's the
judicial
thing.
complaints.
If we make a effort, some people here already have to do court observation. Could we not do judicial complaints when the judge it's an obvious violation of a canon that we're witnessing?
So
and and
good.
and and, and I
Yeah.
think I think that even stem from what Talib said earlier, then what Hassan said, and then what
Proceed.
you're saying here now, Malika. But I think in doing so, we must recognize at least, just saying broadly, the separation of powers doctrine, right? And I've seen it even most recently. At times we think as if, okay, because the legislature says so, this is what the legislature says, but we don't recognize that the judiciary has its own powers too, and according to the doctrine, they are looking at the function of the court.
Yes.
Just for giggles, huh?
And adding on to what Malika just said about court watching, I think we should all be doing amicus briefs and amicus motions, and we should be involved that way too, because we have the right to if we're witnessing in these courtrooms what's going on in the court case. we have the right to submit amicus documents.
Do we?
It doesn't necessarily mean that we have a right to submit it because I've seen court ruling prescribe who can make amicus
Yeah.
briefs. It
Court rules
doesn't,
usually
yes,
prescribe, but it
yes.
is in the spirit of when we seek corrective action against the judicial actor.
Because I think just for argument's sake here,
Because I
right?
think we should submit when a judge, like in Oz's case, for example, says the judge is a good guy. I mean, the attorney is a good guy.
Or don't bring none of that constitutional stuff in here.
I don't know about that because if again they are asserting it's an administrative policy for employees, then we should be highlighting that
Excuse me, I don't work here.
you are outside your subject matter instead of going my constitutional right, because it is appearing that you work for Target, you're supposed to be wearing your red shirt when you're on the clock, but you're in here arguing that something about the Constitution says that you can object to wearing your red shirt when you come to work. We see how that's a ridiculous argument, right?
Right.
I do have a question pertaining to that.
We don't have to
Well,
see how it's a ridiculous argument, but I'm asking you guys to speak up, including the asker of the question.
Yeah,
okay.
I'm saying the essence of the constitutional issue is Article 1, 814. That we don't have to be subject to it, but they do. They swore the oath.
Yes, they're
They
just
are the
saying
employees.
you too. What's happening
They're
right
saying-
now is they're saying you as well.
And that's the reason why I'm saying we should be, even if it is irregular to be submitting amicus briefs and motions.
I think it should be in the form of judicial complaints for their obvious bias,
It would be judicial
appearance,
complaint, yes. And I'm looking what's
the appearance of impropriety.
And private notices. We can do private notices as
Absolutely.
an observer. Yes, as an observer in the courtroom, private notice to the court, notice to the.
And we can do it before and after.
but
Perhaps they'll be on better
but you
behavior.
see in order to do the private notice, we have to first recognize, as saying, just as how we would say, oh, the legislature is doing that, or saying that they are legislating from the bench. It's not necessarily that they are legislating from the bench, right? Like just the typical tenant at sufferance, like McGarvey's experience that is about to share, right? You realize the judicial deference, the judicial choice, it's for convenience. Because think about it, Malika, if the ejectment, if they're exercising the function, right? If it is ejectment, they are looking at it of gonna be a ton load of cases. That's not gonna be anytime soon not be adjudicated, like a lot of cases. So they are trying to avoid that, and while having the summary dispossessory action used to make people homeless.
That's called, for all the newbies out here, abuse of process.
Mm-hmm.
Abuse of process is when someone uses a legitimate process that has a specific intent to accomplish an ulterior result. Questions, comments about that? Abuse of process.
Absolutely is abuse of process.
Abuse of process is when in dispossessory actions, aka unlawful detainer, eviction, if you will, that is created and intended to be for commercial and agricultural tenancies, are used to make people homeless, which is against public policy.
So if one is to be an avid interpreter of the prescription, then every interpreter of said prescription should be like, this is the wrong vehicle.
Correct. Which in their language equates to venue.
Correct.
This is the wrong vehicle. This will produce a result ulterior to the intent of the legislation that authorized this procedure.
Malik, I got a question.
Lisa, was that a good example? Hold on a second, Cam.
Okay.
Was that a good example? The correct remedy for a common law removal is called ejection. Ejection in every state. What the attorneys are doing and some of the landlords themselves is abusing the process for eviction. The legislative intent for eviction is not the same as for ejection. Yet they're abusing the process of eviction, unlawful detainer, dispossessory actions that are for public buildings and business use property in order to make people homeless. That's the ulterior motive.
And court, which is supposed to be the empire, is not calling the balls and the strikes.
Did you guys hear him?
No.
I
I heard him, but I didn't make it out.
I said the court, which is supposed to be the ref, the empire, is not calling the correct balls and strikes because they would be rejecting
Correct.
the procedure.
Correct. Or evicting them for being improper. I'm sorry, ejecting their cases, right? Dismissing their cases or improper venue.
Right.
So when you are brought to court in summary proceeding, which is exclusive for commercial and public property, they expect us to know and object to that.
And we can add in, even though what you're saying is absolutely true, so maybe I'm just refining in a bit, that especially in foreclosure cases, they're using a vehicle that I think is explicitly prescribed for a landlord-tenant relationship that is not evidenced, nor does the record reflect that it exists.
Well, is specifically, and another example of the abusive process that is allowed to be used against us by the judiciary, which is supposed to know better, is in foreclosure. It is implied, listen to me carefully, implied that there has been a breach of contract. However, there's never any allegation of an actual breach or a proving of that breach. It's the same thing like when they use abuse process of ejectment, well, or I should say eviction for ejectment. The judiciary and their deference to the executive branch is a violation of the separation of powers doctrine.
Uh-oh.
But before I go on, guys, make sure you download our Newbie Tuesday guide that has been shared in the chat here on Zoom. If you guys can share it here on TikTok, that would be awesome as well. Appreciate you guys. See, most newbies are not encouraged to read, comprehend, and use the Constitution.
Nor are they inclined to make what we're speaking on or how we're speaking about it a lifestyle. Being in this law space is not a microwave result, it is a lifestyle that must be considered and taken seriously.
Yes.
All
I
right.
remember my dad saw my private plates and he was like, "Ooh, I want to get me one of them. They save you a lot of money every year." I was like, "No, Daddy, it's not like that. This is a lifestyle. You're not just gonna buy the tag, throw it on, and that's it."
Word.
All right. So if you have any newbie questions, go ahead and raise your hand and we will make sure that we get them answered, addressed, redirected, concept correction, as our brother Hassan calls it.
Indeed.
All right. So McGarvey had his hand up. Come on, McGarvey, let's hear it.
Okay, so it's not, I don't know if it would be newbie, but it's definitely in the vein of judicial disability and
Okay.
such. So, and I have the proceeding recorded. So I went to the hearing today, and the attorney actually entered the entry of appearance as soon as he walked into the court, and he served me a copy and he gave me a certificate of service and such, and then I waited until about 12. So I had got there at 9. I didn't there was a judge there. I thought I was going to see the new judge, but apparently it was the same judge who was in the back. So I ended up going back there, and the judge basically wasn't hearing none of that stuff, like the Rule 31, the Rule 40. He said he denied it. He said that I asked him why, like what basis of law he was using. He said that he already made his decision, and then he ruled in favor of Federal Home Loan Mortgage Corporation, and I have 7 days. That's what he said. And so I had also did a judicial notice and a notice for the lack of candor to the tribunal, as well as something else. I don't have it in front of me right now, but he said he denied that. He didn't really give
How
me
do
a
you
reason.
deny notices?
Uh, that's an excellent question. So then he asked me if I had anything else to say, and I was like, "It seems like you're just gonna deny anything that I say, and you're not providing any reason. So there's nothing else that I can say." So then he said that we had an evidentiary hearing. That's what he said, and I asked him when. Like I said, when was that? I'm not aware of that. I don't understand. He said he doesn't care if I don't want. He doesn't care if I understand.
Oh
When was the
wow.
evidentiary hearing, though?
He said that the evidentiary hearing was held the first time when I went, and they ordered the continuance, even though we didn't have anything. But it was like a setup from the jump, because he said he took the attorney. He said that we had the evidentiary hearing, correct, and the attorney said correct, and I was like, apparently they're saying that the first time we had the hearing when they issued the
And
order
what was
to
the
continue.
evidence?
There was no evidence. There wasn't. We didn't even get to anything because I had raised the appearance thing, and so he ordered the continuance before we had even got anything. And then he tried to give me a copy of the deed, but I told him, "Did you file this into the record?" He said no, so I gave it back to him. I said, "If you're gonna file it, you can file it and then serve me a copy." But so there's no deed on the record. I just have those motions. And then I had did an oral motion to strike the affidavit, and I went over it. I'm like, I have the copy here. It's not approved or dated at the space that the form says it has to be. I don't know why you don't. Why would they put the form? Why would they put that there if it
But
wasn't
did they
supposed to
put
be
it into
signed?
evidence? Was there a witness that was it cross-examined about the evidence?
About what evidence?
The one you just said. Somebody didn't sign something where they were
Oh
supposed to.
yeah,
Was
yeah,
that?
no. I had put that in my notice and in the motion.
Mm.
And that he denied it. And then I did an oral motion at that time. And then I was trying to tell him this, and he was saying that it was signed, but it was signed at the bottom part where it said summons. And I asked him about the part that had the date where it said it's need to be approved by the deputy clerk and the day that it was approved. It's supposed to be signed and dated by the deputy clerk. And then the title and capacity was also Vernonburg. And then he says, basically, get out of here with that. And I'm like, okay.
Okay.
And I'm just like, okay, bro. Like, and then at the it had like basically like, you know, when he said that, do I have any more motions? And I was like, you're just not gonna do anything, you know. So, and then there was like a period of silence, and I just asked him to give me the reasoning, and he kind of like gave like a he said that he asked me about Rule 31, and really I should have been like, are you asking me because you don't know, or why are you asking me to explain to you
Exactly.
about Rule 31? But
Exactly.
anyway, I literally started to read from the paper, and then I just kept going because he was trying to cut me off, so I tried to get it as fast as I could, and then he started barking on me. He said, "Hey, are you deaf?" And then all that other good jazz, and
Really?
yeah, and I said, "No, Your Honor, I'm not deaf." And
Oh, the
he
judge is
said,
jumping in the line of fire for them.
yeah, he said, I may hold you in contempt of court. Now, when I tell you to hush, whatever,
I
he was
may
pushing
hold
me,
you in
all type
contempt.
of
It
stuff.
only is for officers.
Yeah, so there's that. And
I'm
I mean,
assuming you did a judicial complaint, and that's probably what got under his craw.
no,
Oh
no, no.
no.
And it's interesting. I didn't do a judicial complaint. I did a bar grievance against both attorneys, and I got a notice back from the bar, I think a couple days ago, and they said that because there's pending litigation, they can't do anything about it. And they like said, "Oh, we seen that you complain for among other things, how the whatever notice of blah 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 blah." So I called and left a message. I'm like, "Yo, if I just clearly catch homie in a lie, are you just saying that he can slide like that?" And I haven't got a call back. But but I haven't done a judicial complaint yet. This had just happened like earlier today, and I'm just kind of cooling off from that. And this time the judge didn't give me the order; he gave it to the attorney to file. So that's interesting too, because last time he gave me the continuance, but this time he gave the attorney, I guess, the judgment because he said he ruled in favor, and he really wouldn't give any, complaints. And like I said, I have the call recorded, or the hearing proceeding recorded. So it's about 16 minutes.
I haven't heard you mention anything about or anything in reference to the court's function to determine whether or not the landlord is entitled to possession or whether or not there is any landlord-tenant relationship. And
That
that was
was
that was the sole purpose for that hearing.
what do you mean?
The purpose of the hearing was to determine tenancy and a landlord-tenant relationship.
Okay, well that's I guess I missed that completely because I when I brought that up, even in the initial hearing, and it was also in the motion, he just denied everything.
It doesn't mean you should not go back and speak on other issues, you know?
Yeah.
You should have reached out to me even before you went to court, man. You got to me after. Next time you reach out to me before, please.
Yeah, yeah, for sure. But in the initial answer that I filed, I had made that a mention for sure about
Yeah,
how
but
whether or not. Go ahead.
you still didn't say anything about it this rising.
Okay, yo, no, I didn't. You're right, I didn't
But
because I, I
that
was
was
I
the
was just
sole purpose.
Yes, the purpose that hearing is to decide whether or not the landlord is entitled to possession. Nothing else. What
okay.
arguments must be raised to support an objection to such assertion or question? But you have 7 days to do a petition for review, bro.
Yeah,
Not to vacate, but to do a petition for review. The judges, most of them, they don't tell you. They'll tell you have 7 days. Georgia law only give you 7
Yeah,
days,
but he
but
said
they're not
7
telling you.
days to get out.
Yes,
that's what he
they're not
said.
telling you. They're not.
He's not going to offer what a remedy is supposed to be, which is
Some
basically
does.
what
Some.
Linnea was saying in the beginning about them not upholding
Yeah.
and
Yeah,
protecting
protecting the
the
rights. Yeah.
rights when that's what they took an oath to. So if you were protecting rights, okay, why would your statement be
Georgia law only allows you
you have
7 days.
7 days to get out? Does that sound like protecting your rights?
When the statute still promulgate 7 days upon which you can do a petition for review to have the matter escalated to the higher
If
court.
I was protecting rights, I would say that part. Assuming I even rule against you. if I were protecting rights. When I'm not protecting rights, I tell you have 7 days to do what?
Get out. Y'all want to hear it?
Do not argue with me. Okay. Explain, what you asked me. I've explained. Order on defendant's motion to dismiss. Now that I've signed the order today. Also find in favor of federal home mortgage, and you need to be out.
I didn't hear
It's
a thing.
going in and out, bro.
I heard you need to be out.
That's all I heard too.
He said you need to be out by the 28th. I don't have my speaker with me, but hold on, let me see if I can find a speaker.
The same judge who was assuming for the attorney. That's right. That's right, Cam. Lawyers are exempt because homie is in litigation. No, not necessarily, but again, when we do bar grievances and we do not include evidence, it's likely to be mishandled arbitrarily and capriciously.
The
Also,
procedure swing both
there's a
ways.
question about he said the attorney filed his appearance today and gave a certificate of service today. Does that sound like service?
Not to me.
Meaning it
And
was
the
a new
attorney,
attorney?
no, it was the same one that appeared the other time that didn't give the entry of appearance, but he had entered the entry of appearance into the docket, and this morning,
Today is still a question.
today, yes, today. I'm sorry, today, this morning, and then he served me a copy of it
So
with
now
the
he got two
certificate.
on there. One filed 5 minutes after the last event,
Yes,
and
after the
then one
continuance
filed
this
today.
morning
A
before.
second one
Yes,
filed.
yeah, uh-huh.
So who submitted all the evidence that he ruled on? Who was
He
that?
said when I was objecting to the evidentiary hearing, he told the attorney, state your position, and then he said I agree, or some type of, I don't know what he said, and then he said, okay, now we're moving on, and then that was it. And then he was barking on me, so I was just trying to raise everything that I could possibly remember at the time.
But
I
you're
would have
not
brought up
supposed
the
to
tenant
raise
at some point.
everything you're trying to remember. There was only one point of the hearing.
Okay. Well, yeah, I totally missed the point of the hearing, because when I was doing the other stuff, as far as like the standing and capacity and such, that I thought that
But
was
you weren't supposed to bring that up again.
okay.
Today's objective was to establish if there is in fact a landlord-tenant relationship.
So I
Resist the
just gotta.
urge to throw everything at the wall at all times. And this level of court is considered a court of no record. People in Georgia or familiar with Georgia? Is this level of court considered a court of no record, guys?
Magistrate court, yeah.
A court of no record.
Yeah, I
Okay,
mean,
so the way to
the
handle it
documents.
is
Mhm.
the review.
Review or do you know of a petition for review, or the do you know of appeal? Appeal de novo, whichever one.
How do you know which one to choose? What's the difference?
Well, whether or not it was legal error, or for the matter to be actually retried in the Superior Court.
Okay.
The petition for review is to review for legal errors, while the de
Yeah.
novo appeal is to have a new matter being heard. So I would do the new matter to be heard.
Absolutely. Let's get that evidentiary
Yes.
hearing and get that
Where you have the
landlord-tenant
full you
relationship.
because you will now have the full applicability of the Civil Practice Act since the judge actually even denied the Rule 40 pretrial discovery. But
Exactly.
this is why I'm saying now the judicial branch appears to be the one that has the most dormant power. Because you are using the court to bring relief when the court is the one that's choking you.
That's a
Mhm.
fact.
That's what our
And
friend.
that
Go ahead.
that's why I'm saying now, even to do the court watch or write documents, we must comprehend how it is looked upon, whether or not the function of the court that is being exercised at the time, or the function of whichever branch that is being exercised, that is what really matters in terms of posture.
Yes, like when we ask what was the capacity that the sheriff was acting when they did their deed,
Mm-hmm.
whether it's giving you a ticket, evicting you from your home, right? What capacity were they acting in? Were they acting on behalf of the state or were they acting on behalf of the county?
I found the speaker, guys. If you want to hear this, okay.
Well,
Man,
y'all want to hear? You don't have to worry about that. You
because
already
she
got the result.
upload it in Lawful Living on the
Yeah,
website,
put
man.
it in the website.
On a assigned presentation, man. We're gonna talk about some certificates.
You wanna
Yes, the season
Jordan McGay wanna
finale.
get to the Sesta we trust.
I'm observing, I wanna hear it too,
Oh no, that's
The,
what
the
I was saying.
six,
That's what's getting uploaded to the Off Duty Alibi YouTube
Oh,
channel.
I thought you were
But we,
gonna
but we
use
went
a
over
screen
it.
now.
Remember, we went over it last Saturday. But I could show a bit of the document about it. I could show that. I'll wait. I can show it towards the end.
Easy. Hey, I think Betty Louise mic doesn't work. She's asking a question in the chat.
Okay,
I'm not
Betty
sure.
Louise, go ahead with your question, comment, emotional outbursts.
Can you hear me?
Yes.
I feel him. It's hard when you live in it, but um I just I've been going through I ended up in foreclosure with servicer. Lawyer jumped out and started doing all manner of things. Come to find out is because of the FHA loan, I qualified for um whatever you call it, the modification. And so now they're offering me a modification, but he got a default judgment on me. Meanwhile, he keeps saying he may not be able to get it out of the court. I don't understand what that means. Like he wants me to sign these papers and go back into this loan and start back paying. And I want to save my house, but because they got this default judgment, the judge won't even hear. Like you're supposed to be able to go back in there, and he won't let me come back in at all on no reason. He says that even though I'm saying it's fraud, because I even told
Hold
the lawyer,
on, hold on, hold on.
all
You
right,
were what state is this?
Minnesota.
And you were sued for foreclosure in Minnesota? Minnesota is a judicial state.
It's a non-judicial,
It's a
but
non-judicial state.
yeah, but because I was like the way he was trying to do things, he ended up taking me to court because I wouldn't comply. And then
So what was the action that they brought against you?
foreclosure.
It's
Yeah.
a non-judicial state,
And he says it's
but they sued you for foreclosure.
yes, yes.
Okay.
And the judge agreed.
And
And they oh so
you
some of
said
the
it
stuff
was hold on. You said it was a default judgment, correct?
right
So a default judgment for all you newbies out there is when the defendant does
doesn't
not re answer officially answer, or otherwise defend, even in a dispositive motion like a motion to dismiss. So if you do not reply or respond at all, that's typically the grounds upon which a default judgment is entered or even requested. So, Betty, is it that you did not reply at all when
I
the
wrote a
foreclosure
letter.
case?
I didn't know like there was rules to court.
Do you guys hear this?
I
Like
wrote a
that
letter to the
honesty.
judge and told him like I have a letter from this lawyer saying he knows that there was
Okay,
fraud.
hold on. Hold on. You went in there and said things with your mouth?
No, I wrote him a letter. The
Okay.
judge.
So you wrote a letter directly to the judge.
Yeah.
All right, newbie people, when someone is asserted as a party to a case and they send a private letter to the judicial agent, it is considered what, guys?
Nothing.
Ex parte.
That's
Ex
what I was about to
parte,
say. Ex parte communication.
ex parte communication, which is disallowed unless under specific circumstances.
Yeah, I told him I needed more time, that I had a medical procedure scheduled and I didn't have time for this. And this attorney was
Ain't
on some,
nobody got time for that.
right, that's just how I felt. I was like, he is on some donkey. He need to go on
Put
about
a
his
one in the chat if you ever
or he
felt like
get
that.
jumped.
Somebody is trying to pursue you, whether in court or pre-court, and you're just like,
So you say
I
this
don't
where
have
you work? That's how
time.
I felt. Like, so you say this your address where you work? I'll see you there. That's how I felt.
So one thing I want everybody to know is that it is always the attorney coming after you. Do you guys hear what I'm saying? It is
Always.
always the attorney
Always.
coming after you. They will tell you it is this bank, it is this servicer.
So they had hit my
It
credit.
is the attorneys and the attorneys only, which is why the judges will put their neck out sometimes, not all times, to not have the attorney prove their authority
And that's what I said.
and not have the attorney prove the capacity that is required between the alleged plaintiff and purported defendant.
Because the judge say, I know him. He don't, why do I need to get him to prove his authority? I already know.
Wait. They put this in writing?
I'm trying to find, like, it was
Yes or no?
something.
Was it
I
in
believe so,
writing?
yes, because I never talked to him. Yes.
They wrote this down.
Somewhere I gotta find it, yes.
Do you guys hear what we're talking about? So just today in a consultation, and
Yep.
I have a witness, which is why I love when my colleagues show up in my consultations. I just want y'all to know. Of course, they're all recorded, but that live witness, nothing can beat it because nobody could claim it's AI.
And so I told him
He
about
had to,
the fraud on the account, and the judge said
yeah,
me and him
when you say
already talked
told
about
him,
it.
wait, remember, we already established when you are telling someone, specifically the judge, anything, the way you tell it is just as important as what you are saying. And when people say things like, and I told the judge this and I told the judge that, and we don't have any clarification if you told them through
It's all through writing.
acceptable channels, I should say, aka you filed a motion or you filed a judicial notice, in the proper use of a judicial notice. It matters because we'll say things like, I sent them all this stuff and they ignored everything. And everybody's thinking, oh my God, how horrible. And then you never file the motion. You never file the judicial notice. People will say, Well, I left them a message. I sent them an email. Is that the way that court?
That's how I'm talking to
She was
them.
very she was very honest by saying, and I appreciate it because this is a perfect newbie question. She was honest to say, I did not know court has rules. And that is a 100% of us in the beginning. We know checkers has rules. We know tennis has rules. We know basketball has rules. We know baseball has rules. Okay, all the soccer, everything with a field and a court. We know absolutely certain has rules, but for some reason when it comes to the court, we don't know that there are rules.
So I'm trying to read through these motions because, like, I ended up putting in motions. I didn't know I had to pay to go to court. Like, you sued me. Why am I gotta pay?
That's a misnomer when you're demanded to pay, especially to so-called defend yourself. That's again something that we should read the rules and see if that is proper or something we should object to.
So then they denied my waiver of a fee, saying it was frivolous. And I was like, frivolous?
Right, frivolous. I'm poor.
Like I ain't budget this. What do you mean? And I guess he figured since I'm not paying the mortgage, I should be paying them. I don't know. I'm like, your friend brought me here to pay you? No. Y'all all got these bar cards. Boy, the judge included had a bar card because I did find out about that. And so then when he kept responding to my emotions, he was talking. And so he was saying stuff like, we already discussed the fraud on the account. I said, well, I'm saying to myself, well, I wasn't even allowed to be in the mix. So how are you guys discussing my house, my issues?
Good
And making
question.
decisions on it. And so then he never like wanted to see me. So he made sure. So then when I was like gonna pay to go in, I ended up paying to go to bankruptcy
What
court to
what state
say
is this?
Minnesota. So I went to
So
bankruptcy
in
court.
Minnesota, you have to pay to defend yourself?
Yeah,
We
they wanted me to pay
No,
three
no,
hundred
no.
dollars,
No,
three
well,
twenty five for filing,
okay,
and
hold on. Can
a hundred.
someone with a little more experience confirm if in Minnesota you have to pay to defend yourself?
And they wanted $100 per motion. They even sent me a thing saying, well, if you ain't gonna pay and you get hurt, and because I ended up saying I'm going to appeals court then since y'all don't want to hear me.
Extortion.
They got mad 'cause I
Well,
wouldn't pay
that's not.
them. I started mailing the stuff in so they would get it, and I still wouldn't send them money. So they sent me a letter saying,
Yeah.
if you get heard in an appeals court, you gonna owe us. And I wanted to write them back, but I didn't. Owe you for what? You wouldn't listen.
Go ahead, trading.
No, it says there's a fee of $100 according to a particular statute, Minnesota Statute 357, court administrator of district court fees. Right? But yeah, it does. It's a quite a long passage to read.
Yeah, you
But
got to come in with
it's
400
about
Yes.
dollars.
paying to defend
Fee,
yourself.
fee,
A fee to defend yourself.
the court administrator. Yeah, it says to file motion. Yeah, yeah.
You
But it
need
was
the initial
Minnesota
$300.
district courts often requires a fee, typically $100 for filing of civil motions according to the statute. So let me post a link inside here. But it says, well, it's not Minnesota alone. It doesn't Florida as well
I don't know.
as a provision there for
Yeah,
for
they have a fee.
yeah, Florida has a
Florida
provision
has a
for a
fee.
fee.
It
But
say $100, but when
Really?
you get
Oh
that's
there,
wow.
reason that's reasoned if
initial
you haven't.
filing is $300.
So you
An
have to pay a
initial
tax.
filing is not the same
So,
as filing a motion in someone else's case.
so,
To
So you
get
have to
in
pay
the
a
door
tax.
is
Oh,
$300.
so
So
let
you
me
have to
read.
pay a tax to
Plus
defend yourself.
each motion is $100. Each motion.
Hey, I might.
You gotta
And
pay to play.
what's the price for a motion? I mean,
$100.
hold on. What's the price for a notice?
I
Are
don't know.
notices free?
I don't know. I
Yes, the
was mailing
notices are
stuff
free
in,
in
so they
Florida, at least.
Notices are free in Florida.
Yeah, they're free MPA too. You just have to pay like $67 for to do a motion each
You
filing.
pay for motions, but
You could
notices
do
are
a waiver.
free.
That's
You could do
crazy.
a waiver and they'll accept it and they'll put it on the docket. But I don't know how they do it at the end if you lose or if it was dismissed
You see
on your behalf.
why, to me, and I know it's not going to be just me, but I'm going to speak for me. The invitation to court in the first place presumes a relationship between the court itself, the government itself, and of course the courts by extension, and the parties. They presume a type of relationship.
When it's talking about the tax that
A taxable relationship.
no,
They
you know,
presume
um,
that you deal in FRNs, you know, that you if
Or
somebody
whatever the commercial interest in.
that
right, it's like it's an assumption or a presumption that the issue that when they bring you in there that you are acting in their game, you know, in their
Commercial intercourse.
Commercial
engaging in commercial,
specifically,
yeah,
because
commercial
if it's just in the interest
activities.
of justice, why would a defendant especially be charged?
Right. So
it's
it's
as if you're using the court for profit.
Exactly. You are,
exactly.
You're
or at
using the
least
court to
whatever the
enforce a
contract is
contract.
being
Yes,
adjudicated. The
yes,
contract being adjudicated is a commercial one,
And so
and
yes.
both
you could,
parties have a commercial interest only in it.
which presumes that it is all commercial, you know, that like as they say, you know, that all crimes are commercial. I mean, in this case, it's absolute. Like, there's no
It's
questions.
about as we say it here, it's about all commerce being crime.
can I tell you what he
Not
said
all
in his
crimes
motion?
necessarily being commercial,
But
which
it's
is
definitely not
not the same.
justice because justice doesn't require
Right.
FRN.
Justice is not for sale,
Yeah,
denial,
It is
nor
in
delay.
Minnesota. They got
that's
a big old button
pretty
that says
crazy. I've never heard of that.
speech. He
You've never heard of what?
said the motion cites correct status. It says second, the second is a motion to require plaintiff counsel to demonstrate authority to act for plaintiff. The motion cites the correct statute, but is made after the close of the case and fails to entirely to assert a reasonable basis to doubt counsel's authority to act for Bell Bank.
See, guys, what we talk about for reasonable grounds shown.
And then it says the court will not rule on the motion at this time as they are not presently before the court. No filing fee has been paid.
Oh, it's not before the court because you didn't pay them to take a look at it.
But at the top it said the first sentence says the action is frivolous. I filed for a fee waiver. Action is frivolous. Has required a fee waiver to file two pleadings into the post-judgment case. The first motion is for default. The allegations it raises have been
You put
addressed.
in a motion for default or attempted to put in a motion for default?
That's what he keeps saying. The first motion is for
Well,
default.
I don't care what he's saying. I'm asking you.
No, I said I put in for I put in to vacate. I put in a motion to vacate.
And they denied the motion to vacate on what grounds?
He said uh he keeps saying I didn't come to court. They got return mail. I sent them when I sent them that letter, I told them that that's the incorrect address. They need to mail it to the
How
correct
does
address.
wait, hold on.
Yep.
You are not entitled to post-judgment relief because you did not come to court?
2 days.
Is that what you're saying?
Yeah, and then on if you read through the case, he says, I don't think Miss Jones was aware of the time change. So they moved the courts all around. They knew my mail was getting stolen. I think the attorney was coming to my house taking it. I caught him outside my house one day. So then
Yeah, you got
I
a lot of
had
things. You got a lot of things going
a
on
lot of
there.
moving parts.
You
But
caught the attorney
you,
outside your
the
house?
attorney,
Outside
the
my house.
attorney, hold on, the attorney got the default. Defaults are overturned like 99.9% of the time, almost for no reason or any reason, I should say. You can tell them anything. I overslept. Let me get another chance at your earliest convenience to make a proper defense. It's usually accepted.
I done sent in 4 or 5. I got so many filings. I just ain't paid them. Because at first I
So
couldn't
hold
afford
on,
to. And then I
wait,
refused.
wait. If your filings are being rejected for non-payment, why wouldn't you just pay?
At first I couldn't. And then the deadline was coming so quick, I went to bankruptcy
There
court to try
is,
to save
oh,
my
wait,
house.
wait, 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 wait. There is no deadline to challenge a judgment
He took
for
it to the
two
sheriff
reasons.
to sell my house.
Who can tell us the two reasons that the time
Jurisdiction can be challenged at any time and
which
void
one?
judgment.
Which one?
Subject matter jurisdiction.
Subject matter jurisdiction and what else?
Void judgments.
Void judgments or fraud. Remember, it's under Rule 60. Rule 60 has all of that. Remember? Does anybody remember our Rule 60 conversation? New people? Because under Rule 60 or the equivalent in whatever the state may be, some of them are call it something different. Most states still call it Rule 60. You have void judgment, fraud right there. The judgment was secured in fraud, the judgment was void. You have them. So it's either Rule 60 or it's subject matter jurisdiction. Those two things don't have any time. So I recommend to Betty to educate yourself on those. Disqualify the judge if you need to, because if they're actually saying and you have recording either in writing or audio that they're saying these are grounds upon which you can show they have violated their canons.
This sounds like a
And also
typical.
that they cannot be impartial.
These are on the denials. This is what he wrote on the denials. I never talked to this guy. I never went before him in front of the court. I never showed up. That's why he mad because he set up 2 appointments and I never showed. And he keeps saying it. You could see it in his writing, like he's angry about it. He's like, I gave her these days, this 7th and the 27th, and she never showed up.
Okay, so
And then he says it. He says she don't want to pay. It's closed. I'm not going back. She didn't pay. A frivolous. We already talked about the fraud. When you weren't here, you should have showed up. He says there's no reason for me to doubt who the plaintiff is and that he represents this guy, this bank, and blah blah blah.
yeah, you made a lot of missteps that allowed those grounds to be stated by the judge.
And so in missteps, you're saying,
well, they got a default judgment. You put something in. Did they reset a date and then you didn't show up?
no. You know what? When I first wrote the letter, I was saying, I might be available after my procedure.
I'm just saying.
Yeah,
You're
so
gonna
that's probably
determine it
what
another way.
and so that may be what he's speaking of.
That's why it's important to not just throw the judge under the bus. You have to look at the record. You seem like you just realized that. So I'm glad you brought it up. I'm glad you had a chance to think about it.
I have a question. My question is, how did you come into knowing about this law space? Like,
How
what was your motivation?
I first came in with the reparation, I wanted to learn more about the tax portion. And then when I saw what she was, when I was waiting for the reparations class, I started viewing the up and down, what is it called? What goes on above, go on beneath, or whatever that class is.
As
And
above, so below.
yeah, and I didn't know. I mean, I knew about the Constitution, but I didn't know I had rights. I kept saying I got rights.
So let me go and continue in my line of questioning.
Congratulations.
My line of questioning is based on um what is it that you're good at, sister? What do you do?
Me?
Yeah, hair,
Oh,
nails, your contract. What is it that you do?
Can I just say
oh,
I love your honesty? Sorry to interrupt.
I've been doing hair since I was 14. And then so I've been self-employed most of my life. And then I went back to school for finance, econ double major. Never knew I had rights.
Okay, so with those things that you know, just without you thinking about anything so-called professional or government like, even with hair since 14, was there a certain protocol in your approach to doing hair, or you just randomly did whatever came to mind?
Um, what do you mean? I
Like,
mean, it's a
did you grab
broad.
a comb? Did you grab a brush? Or you just like, you know what? I'm just going to
No, I got
slap
tired
me on the
of
head when it's
waiting on
done.
my cousins to do my hair. My cousins did my hair, and either my mom would beg them, chase them down, and then they still didn't want to do it. So then I taught myself how to braid my hair, and then ended up being really good at it.
Okay. I think that same approach that you did in taking care of your hair is how here in this space, in this law space, we would, instead of the hair, it would be how one cares for their affairs, especially when people are making nuisances, right? A nappy nuisance situation, let me say, right? Out of you're just trying to, have your shelter, you're trying to, rest your head when you want to, take showers when you want to, cook your food when you want to, right? But
Yes.
the nappy nuisance is when you have these attorneys who are banking on you not knowing how to do your own hair, not knowing how to handle your own affairs. And so, since you took that seriously with hair, are you willing to now adopt as a lifestyle what it takes to really be really good at
Do you
knowing how to fend
know
off these people?
how long her classes are? Like I signed up for um the all access pass.
Is that a yes
Yes,
or is
I'm
it a
so
no?
dedicated. Like
Okay.
I'm so thankful for you, the balls that it took for you to set this up. I just praise God for you.
Gratitude.
And I'm thankful. And so I
Gratitude,
listened
man.
to all your, I mean, 5 hour classes, this one class. Then it's like 3, 4 classes. I'm sitting there listening to all of it. It took me a year to get to where I could comprehend this much. I mean, it takes so much unlearning.
It's so true.
And then
Absolutely.
like I had a health issue, so I haven't had the money that I'm used to having. So that's been humbling. With my I have a arrogance problem and so much. But hey, who doesn't have a suitcase of whatever? And so I wrote the judge a letter saying, this dude need to leave me alone because I already told him that they had altered my documents and he didn't care. He just wanted the money and he put it in writing. And so I just don't know how to grab him and beat him senseless in this court situation because he's documented that he's hustling me.
What it seems to me though, that it seems as if it's maybe ripe for a 1983.
Interesting.
What do you mean?
A
I
nine.
think, go
Go
ahead,
ahead,
bro.
Malika. Go ahead,
No,
man.
no, no. You go ahead and explain. I was going to explain what a 1983 was. A 1983, for the newbies, is a section of Title 42 that is, has, and can be used to keep government actors accountable. It only has two elements. And number one is a deprivation of rights under the color of law. And number two, or because it's only two, is that it was a state actor.
Well, he then went to the sheriff's, and I'm like, he done violated every FDCPA. I just don't.
But they're not under the FDCPA when they're performing that particular function.
Obdusky.
Well, once the bank says that it's in default, he becomes a debt collector.
Research. Go ahead.
No, you go ahead, because
I'm
I just
telling
want
her
to
to
tell you
go
that statement
research.
is untrue.
Is it?
Go ahead, tell her the case,
I'm
Trading.
telling her to go research the 1983 civil complaint.
Definitely.
Against the judge who is considered a state actor, someone for whom the state is responsible, as well as who was the plaintiff.
I was, and then he put
You were the
You were
plaintiff.
not the plaintiff in your own
Oh no,
foreclosure.
I was the defendant, and
Who was the
HUD.
plaintiff?
He put HUD, me, and
Who was the plaintiff?
Bell Bank.
BELL?
Yeah.
Go ahead.
Yeah, Bellbank could be one of the defendant as well.
No, he put him as the plaintiff, and he
You're
was.
not listening.
I'm saying when you
for me.
in looking at the 1983 complaint, that's a federal venue and it does require a plaintiff and defendant. So I was just identifying for you based on protocol who the defendants are.
Plaintiffs. Okay, so I would be the plaintiff, and then the defendant would be the judge, the bank, and this lawyer.
Well, you could just do the bank. You don't have to do the attorney. You can do the
you can't
attorney
just
as
do
well.
the bank in the 1983.
Yes.
You have to hold some state actor.
Because the bank is considered a private entity
Yes,
that
and
has
if you
no
want to hold
use.
the bank accountable, and this is again for the newbies in 42 USC 1983, if you want to hold a private actor, either an alleged private entity like a bank or a private man or woman, they have to be acting in concert with the public actor that you're holding accountable. It cannot just be a private party being held accountable under a 42 USC 1983.
Yes, it has to be structured to reflect that what they call entwinement. How it is that the private actor did use a state created right or privilege,
Or
which
no,
would
they
be
had to have acted in concert with the state actor. It doesn't matter which part they did. But in order to hold that private actor accountable, they have to have acted in the scenario with the public actors in order to also be held accountable under 1983.
So that would make the bank or not the bank.
It depends. Who is going to be the state actor that you're also going to list as a defendant? Because if you don't also have a state actor, you cannot hold the bank accountable under a 42 USC 1983.
So it would. So you mentioned this. I don't really know, so I'm asking. I guess would it be the judge, the lawyer, and the bank, or it wouldn't be?
Who you decide to name as a defendant depends on what it is that they did in conjunction with the other public actor. So that's how you determine who you're going to include.
If I recall from the beginning when Louise started, it sounded like she said there was a foreclosure case with a servicer. I think that's the first thing I heard.
It was.
And then that makes me think, what I immediately think every time is, does that servicer know that that attorney is bringing suit in that servicer's name?
I know everybody's like hearing things at different points in and out, but when she addressed that, the standing of the attorney, it was post judgment, and the motions were not being entertained without payment, and also objected to for being post judgment for that
Got it.
particular challenge.
So she would need a reinstitution of that case in order to have a meaningful
She
opportunity to be
probably
heard.
needs to go research 42 USC 1983.
Got you.
That's what it seems like. So that's what I would recommend. Go search for research of 42 USC 1983. For those who are not aware, we go over that in our sue along class. So if our affiliates are here and they want to link to the sue along class where we focus specifically on 42 USC 1983s, I would encourage you guys to share your link.
So I watched those classes as well. And so the first thing you would do is send a letter, right?
I think you should watch the class again and then actually do it. That
Okay.
is going to be your best teacher.
Okay.
All right. Gratitude for the question. I'm glad you have that class. So go ahead and dive into it.
Well, thank you. I appreciate you guys.
Gratitude. Marcel, welcome in, bro. I just want to say that you've been on my heart. I don't know what's up with what's been going on, but you've come to my mind and to my heart several times in the last
My
couple months.
goodness.
So I'm glad to see you.
Well, I did order some plantain chips, so
It's funny you showed up today too, bro, because I'm actually dropping a video on what is a Seta K buy and a Seta K trusts.
oh yes. The bearded one has been addressing that, so-called addressing that. So I look forward to that. Yes, tomorrow, I have the case that the trustee is pushing for with the 13. Now, interesting enough, the state case. So that we're going into May, right? So the chapter 13 was filed July of last year as a stay. They are furious. We're headed to a year of this stuff. And then the tort claim, well, the tort claim has been stopped. Well, they haven't made a verdict yet. All the guys were trying to jump ship and so they wanted the last one was the judge. And so just learning from the class, looking at what using what Hassan has given me, that no, we're not arguing that, we arguing capacity. Did he ever have the capacity to call for any of this, especially when there was a stay already, and the fact that he did all these within a minute to
Come on, in the middle of the night. Why they want to act
listen,
like that don't mean nothing? It means
listen,
something. Was the judge
yeah,
asleep signing these? Was
I that
someone using auto pen? What exactly was happening?
whatever
Inquiring minds
whatever I
want
filed
to know.
has frozen that thing for 6 months. So that I filed that in November. This is November, December, January, February, March, April. So we're about to hit to May. So it's about to be 7 months with the state tort claim, just waiting for a response with that. So, which means that the judge from the 13 said, we're not moving until that's finished. Well, that's not finished. So the trustee is saying this is taking way too long. Now, the judge in the last hearing said, hey, can we just wait until that's finished, however long it takes? So now the trustee is saying, no, we can't. So we had a date in February, but it was moved to April 22nd, which is tomorrow. So I motion, they did a reconsideration, and I motioned, filed a motion to deny it. Like, no, nothing has changed since the judge gave that last verdict. Nothing has changed lawfully. So to justify anything for you to demand anything. However,
Correct.
Loan Cash stopped sending me mail from mortgage attorneys. I haven't heard anything from these
Wait,
guys.
what?
Now, so I'm
They
going to my
stopped
post office.
sending the statements?
I'm going to my post office tomorrow because they may have, and I'm just not getting them. Who knows? So I'm going
Okay.
to make sure that my PO box is good because I got a
Okay.
letter. But so far, I
We
haven't
only want
seen.
to count the eggs that
Right,
have hatched.
right. So, but it's just that situation has been interesting. I'm waiting for the tort claim. She didn't. We're at the default judgment part. I don't want a default judgment because
You don't
I
want
want.
them to come back.
No, what a tort claim is for. No, that's not for a separate tort claim for the children's
Yeah,
mother.
but in a default judgment, somebody can come back and be like, "Oh, I didn't get mail. I was out of town. My
Oh,
my cat died."
yeah,
Okay.
because I want a jury trial. I mean, a hearing for the one with Vanessa, and they like. So my thing was like, you need to go in and put in a default, have the judge to file in a default because it's been 30 days. And I'm telling my thing, do hold on, do I want to file a default? I asked for actual hearing for them on behalf of constitutional rights being violated. What am I talking about a default judgment for? So no, you want to be able to do a default. So I'm going off on the chat. Listen, you communist socialists, what is up with you, man? Stop with
You
is this
can get a default. I
I know,
mean,
I
it's
know,
not the
I know.
worst thing in the world. Look, guys, he's like, "No, I don't want to win that way. I want to
I'm
win
like,
this
I'm
way."
like, is this thing being hijacked? Are they attorneys listening? They like, okay, we need you to take a deep breath, you know. So that's that. I went to my hearing in February for the contempt. She has still had not been served, and she's been just figuring out ways. I just spent almost $1,000 trying to serve this girl. So I have a new one in April, but now they moved it again to August. So I'm pretty heartbroken about that because now
Oh.
almost 3 years with the still not physically seeing them. I see them through Zoom, still 3 days a week. But I was ready for that hearing. I was like, boy, you're going to jail. And
Mm-hmm. You're
but
going to jail.
oh my
You're going
God.
to jail.
But
You're
so
going to jail.
we have a pre-hearing May 4th. I got to figure out a way to get her a file. I filed for alternate service because I'm showing them that I have it, and they said no, it's not. You don't have enough evidence to justify alternate. I wanted to.
Okay.
Uh, I'm like, are you kidding me? I showed you all the money I paid and pictures and how she. They said you don't have enough evidence to. So I'm like, all right, I got to go back to the drawing board and figure out how to serve her. So that's been a little bit frustrating, but I'm listening to the sister just now. And I didn't know how far along I've gotten until I heard her share where she currently is. And I was like, oh, I remember all of this. And I was like, dude, you've definitely come a long way in 2 summers here. That, some of the stuff she was trying to make sense of was just like, oh, yeah, oh, yeah, oh, yeah. Oh, that's well. And it's like, yeah, when you do emotion, you got to tell them what you actually want, and you want to. And so now it's like I just feel lighter and better. Not to mention, last week I turned 50.
Hey,
Yes,
Woo
congratulations.
yes,
woo! Happy silver return.
yes, and I hit my goal, down 200 pounds. So finally, that, and now my
Yes, we're here for
yeah,
it. Learn
yeah,
the law, slim
yeah,
down, all of that.
Down to
Eat
Mark.
yeah.
snacks. What?
I know, right?
That makes me
So
want to eat some snacks.
definitely. So now I'm going for my ultimate goal weight, which is 6'3", 270. But yeah, so super grateful. But that's tomorrow. And I was like, do I want to say anything? Because I said, well, give me all the questions that I should ask. Because at this point, I kind of know I don't know everything, but I know enough.
You gotta have that chain of title. You
Right,
have to show the being the person entitled to foreclose.
right,
That's it.
right,
The chain of title is what's going to show who has the authority to foreclose.
right. So this is what this is gave me. It said tomorrow, strategic questions. I want to know what your thoughts is. I'll run through these real quick and then let you. It was only a
This
couple
is
of them.
totally not newbie, but we're allowing it.
Oh, it's not. Oh no. Oh no. Okay.
I'm
Okay.
feeling a little jealous. I ain't gonna hold you, but go ahead. I appreciate it, brother.
Oh shoot. What was I just said, oh, it's not newbie. Okay. So I was like, what were we doing? Um, and the first question of Marcel, I just had him up.
Everybody's
Okay.
getting a preview of what we talk about on Fridays.
I know. So final strategy. You're doing something very few people are doing. That's not what oh, here we go. The questions. It told me to prepare for these questions. If they say, tomorrow, what it's really about, you're not there to argue anything. Oh, it starts off by saying, good afternoon, Your Honor, Marcel Maurice Russell, the debtor appearing here pro self-representative. Your Honor, I oppose the motion to reconsider. There's been no change in facts or laws since the court's prior ruling. Most importantly, creditor standing remains unresolved. And I'm not refusing to pay. I'm asking to ensure that payment is made to the lawful party. Until that threshold issue is determined,
That is so good. That should be on repeat.
Oh, really? Oh, wow. Because
I'm
I
not
can't.
refusing to pay. I'm just
No.
asking for it to be verified that I'm paying the right party. And if it ain't you,
That's what I've been saying.
It says until that
Bird.
until that threshold issue is determined, reinstating payments would be premature and potentially improper. For those reasons, I respectfully request the court to deny that motion. And so then I put, let's go with some rebuttals. Why aren't you making the payments? And my response again, Your Honor, I'm willing to pay. But I believe payment should go to the party that has established lawful authority to receive them. Chapter 13, payments are required. Understood, Your Honor. My position is that payment should follow a determination of a claim allowance, and standing under the rules subsection 502 and 506 based on court law. This is the time to argue standing if they say that. Respectfully, Your Honor, standing is a
how
threat.
is it not the time when it standing is a what?
Right. So that's what
Is
I
a
have.
what, guys?
It's a threshold issue.
It's a
That's you,
threshold
bitch.
issue.
Yes.
So that's my response. I said, well, respectfully, Your Honor, standing is a threshold issue. Without it, the court cannot determine who is entitled to receive the payments. So that I just told myself, don't go in there all over the place. Give 3 or 4 points tomorrow. Keep it simple, and we'll see where we go from there. So I can't wait to kind of tell you guys. But that's just what I had looking forward to tomorrow. But before I wouldn't even known what any of this. Like now, I'm like, oh yeah, and do that again. So, no, that's not the point. It's too long. Can we simplify that? It's just it feels good to even be at this place.
Did you draft that script with either your Maryland Remedy or George Prudence Jim?
Maryland Remedy, Mr. Seven Hassan.
Mr. Seven.
He is
We're like
hilarious.
Ocean's 11 up in here.
Y'all are hilarious.
So my good coach, and he built this, helped me to organize this. Incredibly grateful to you. So, but yeah, I just want to say I shouldn't be excited, and I never want to go into their weirdness.
Wait, hold on. Yeah, he said I should not be excited. Why should you not be excited?
But I'm cool. I don't have anxiety.
Wait. Why? Yeah. Tell the newbies why you said that you should not be excited.
Well, I should not want to even go in there, but if I got to go in there, the preparation feels so good. And I want to tell anybody that's new, you learned everything and was deceived for 20, 30 years. So you got to give yourself grace. Really, this is about a 2-summer journey for you to really, because the first year you're just trying to learn the language. It's kindergarten. You don't even know what they're talking about. And so you're responding back at Google Gaga and you saying it with so much passion, slapping on tables. I done had medallions. I done done it all. I done came in with authenticated birth certificates. I done studied Hague conventions. I done
UCC one.
Touching them soft spots. Touching them soft spots.
I done 2 levels. Oh my gosh!
I mean that is the best, man.
We learned a little bit of everything that is unnecessary.
Marcel, tell them what you did with that medallion. Tell them you went up there.
I walked in with a medallion. It was authentic. It was gold and silver. I paid a grip for it, and I put it around my chain as I walked through the court hallways. And the guy was like, "You need to put that on." I was like, "Yeah, you might." In my mind, I have the ultimate power in this building, and I go up on the stand, and the judge is like, "What is that?" At this time, I shall not. You see it. So I'm holding it in the air, like as though it's going to shine through the room so brightly that they'll be blinded. And so immediately, they're like, objection, Your Honor, this sovereign nonsense that he's doing. But yes, I had a medallion that's downstairs. I think I was the executive. I don't remember. I don't even ascribe to it.
We can safely say you've been through all of the initiative hazing.
Bro, I done spent so much money. I spent like $4,000 one year on mailings going out, and but now I'm doing it all online, and it's just they send something within an hour. I done draft it up and said, I know they just pissed all the time. They like, he responds right back, and I'm eating sandwiches, I'm doing stuff. I'm like, oh, and I just type it.
Nah.
I'm like, no, that's too. And before I had all the rebuttals inside of it and what they might rebut, and it's like the shorter the better. Now it's like 2 pages at much. At the longest is like 4 because I got this certificate of service. But I've learned to argue. It's been a journey, man. So
It
anybody
isn't
that
it amazing that in the beginning, our responses are voluminous, and as you learn more, it shrinks
The check fish.
down, distills all the way to this.
Becomes a
Bird,
check fish.
bird. The bird is a word. The bird, bird, bird. The bird is a word.
Yeah, once you know the language, you like it's like playing spades. It's like objection, or just like Uno. It's like it's you can't do two draws for.
No, Uno.
Yeah, no Uno. It's like I'm not. This is not. And but before you don't know, it's like that's not fair. And you don't know what's a cool card and
You
not a
hear
cool.
that, McGarvey?
Yeah,
Yeah, I'm saying y'all touching these soft spots. I guess y'all just take pleasure in that. It's okay. It's all right. I
yeah.
appreciate it though. It's that's love though. That's real.
You file stuff you think is personal, and it's like no, you're just not speaking in their language, and it's like they too incompetent. You're talking about they're not studying Constitution. You're talking about I think
They
78%
don't know the
of a
First
team.
Amendment. I
They
just
don't,
cannot get over that.
they don't study. I think it was 78% don't even. It's optional whether they take the First Amendment. So you talk
Scalia,
about
a Supreme Court justice that they unalived because of his stance,
Yes.
said
oh
they
wow,
do not teach in law school the First Amendment.
oh wow, I didn't know they unalive that cat.
Yeah, we are.
We got
That's
that video somewhere.
That's madness. But yeah, I just really wanted to thank the squad for just the way as you can't be dependent and free at the same time. And I think when you knew, you just want somebody to fix your life, and you've been so conditioned in the culture that's government and relying and somebody there's a savior and a savior, and then you like, well, I want autonomy and freedom. Well, then you the savior. It's like, wait, no, draft me something. It's like, no. You're the savior. I know I'm the savior, but draft me something. And if it don't work, I want to blame you, and I'll pay you more to blame you. It's like, no, that's not. You got to learn how to get free. It's like you got to go over there and find the key. I don't want the key.
It gets better, Marcel. It gets better.
It gets better.
Yeah, because sometimes we'll assist, right?
True indeed.
Like this,
Right.
right? And then we'll get a message, right, Hassan? So this happened. Blah 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 happened.
Yep,
Did
yep.
you file what you have?
Right.
Yeah, man, that's the thing. That's what I'm realizing. I'm realizing most people, I mean a lot.
Did you file what you made?
Yeah, a lot of people are not doing that. And it's like, whoa.
Did you file the good faith attorney notice? And when people say not yet,
Word.
when that is step number what?
Yeah, step one.
No.
One.
Yeah. So freedom ain't free, and you can't be dependent and free at the same time. That's how I had to learn the hard way. That ain't nobody coming to save me. Not if I want freedom.
Hey, we're all here to help you save you.
Yeah.
And you can't
And
give
now
up.
that you're lighter, it takes even less of us.
Bars.
Yeah, cool. I'll let someone else.
We love to go over you guys' documents with you. We love to go over ideas with you guys. Okay.
Word.
We are here for it. Obviously, we cannot do neither the thinking nor the comprehending for you, but we will do our best to assist in your clear comprehension, even if it's sometimes we might take you guys kicking and us screaming. As
Yeah.
long as you show up, we're here.
And there's no Milli Vanilli option either. You can't lip sync what you've been assisted with. You have to read the lyrics and sing the song for real.
Yes. Yes, that's why we're here every Tuesday, guys. We're here at set times every Tuesday, every Thursday, every Friday. We don't shy away from anything, including criticism. Yeah, we're still taking newbie questions. We got 15 minutes. Gratitude for sharing, Marshall. Always a pleasure to have you.
That was necessary. That was for me. I appreciate that. Really,
Even if
really,
you
really,
bring some
really.
of your advanced energy into the newbie class.
I feel like a newbie, so I'm like, oh yeah, newbie class. And then I'm listening, I was like, you need to mute yourself.
Or you gotta stay in the corner with Hassan, because that's usually and
That's
Lene.
right.
That's how it goes.
It's a seat over here. Come on, pull up a
Listen,
seat.
and you knew guys if what I used to go crazy off if they would say, like you have to do this, that, such and such to come in on Thursdays, or this such and such. I would just I'm dozing. I'm like, I'm getting to that next class. And really it's who you become trying to get advanced is what's most important. It's not that it's like, oh, I completed this thing. It's who you got to become to complete the thing. And then you look at the other side and it's like, this is, and you hear people say, like, this is so simple. And it's all common sense. It's all common sense after you get so much of the fear away. But it is not
Yes.
sense
Did
when
y'all
you,
hear that? The
yeah,
fear.
yeah.
And I hear that that Marcel is admitting to dedicating to the lifestyle.
Yes.
He
That's the
wasn't
only
just
way you're going to
looking
get over the fear. And
correct. He
stop
wasn't
thinking that you're going to correct your status, create some form of trust, or just declare yourself into freedom.
correct. And it sounds like he wasn't, and he learned that there is no microwave result. You must be able to commit to learning how to frame well your articulations.
Yeah. Yeah. That's
Mark
much.
sells a. You can tell he's becoming a completely new man from all this.
Oh, bro. I'm sleep.
Indeed.
I'm sleep. I mean, you gotta understand, man. I'm about to get emotional. I got it to 530 pounds because the fear of it all. It crippled my body.
Word.
You know, the fear. I mean, Hassan goes in a hearing with me and he's yelling at the judge. I mean, I wanted to snatch all uh, noble cloth off of this man. I'm like, what I'm doing in my life? But that shock and awe was important for me, you know, and so I'm sleeping now, like sleeping, you know, and I'm doing better in business and I can focus on my life. Before this was all encompassing. I couldn't, you just feel like you feel like the government made you a slave and you're going to be that way, not knowing that there's this incredible documents written for your freedom. Um, and you just you have to believe that and know that. I have to
Comprehend
put
it.
in the work to
You
understand.
better preach, Marcel.
Yeah, and so you walk in there reminding them, you took an oath to this, right? Yeah, yeah, yeah. I did. I took the liberty to require your oath. You signed this on the 25th of May in '09. Yeah, yeah, yeah. Cool. So I got a couple questions. I just wanted to make sure we was on the same page that you took this oath. So we agree to this beautiful documents, correct? Yeah, called the Constitution, and yeah, yeah, yeah. Cool. This should be fun. And then um it feels I've never announced this, but I lost my marriage over this. Um Nobody knows. And she said this freedom stuff is you keep this.
Wow.
And I said, cool, I understand. And yeah. So I've never even told anybody that yet. Nobody knows. But I took a deep breath and I was cool. Um, but I was like, I'm not living like that. It's like,
You had a brother reach out when there was some sight on things.
yeah, yeah, yeah.
You know,
So, but
you had a brother reach out.
yeah, trust and believe, guys. I'm not like, I'm so, like, I'm cool. Like, uh, it was a slightly devastating, but it was, and some of you guys, you know, there are people walking beside you that you might give up your freedom. My freedom is for my children. Like, they didn't ask to be here. So it's really to teach them a way of, like, Malika speaks such a free way. It's her daddy's fault, you know. When you
It is.
when your parent frees you, it's just different. So my
Yes.
children are starting to talk different, and I'm not giving. They didn't ask to be here, you know. But
They're comprehended, aren't they?
oh, bro, and they don't really know the questions I'm asking. I know what I'm asking, you know, over a Zoom call. But they all are getting 3.9s at school, and honor roll. And all I need them is have a little swagger about themselves. Why? Well, really, why would the teacher say that? Just critical thinking and
Yes.
just that kind of thing. So that was, I can't believe I told you. I told no one. The only one knows is my mama. So, but if it wasn't for this group, I probably would have been a slave because I was getting bigger in the marriage and more depressed.
Oh.
Part of the thing, and I'm not blaming her or anybody, but she was so afraid of just the notion of it all that crippled her. And I'm like, I can't live like that, bud. I can't. And I've got to lose this weight or I'm gonna die. Like, I can't. Freedom ain't free. And so
You
this
at
ain't.
least got to pay attention.
Yeah.
And
So
with responsibility or with knowledge, right, comes responsibility, which is why a lot of people are willfully ignorant.
yeah. So I said I don't wanna know this stuff. I said I'm not mad. It's okay, you got that right. You don't have to leave either, but if you wanna
Oh
obviously
my God, guys.
yeah,
I
yeah,
think a lot of the fear is that people don't really want to be accountable to to themselves, and that's what it requires
Yes.
is that we
yeah,
have to actually be accountable for, like,
With knowledge
understanding,
comes the
yeah,
responsibility.
knowledge
It's
and
like that
comprehension.
movie that They Live, where the best friend, even after a fight, he had to
yeah,
hold him down and put the
yeah,
glasses on. And he was like, no, I don't want to see. Y'all remember?
yeah, yeah. And she
Because with
asked, why you
Marcella,
want your
it's
freedom
like you
back?
tried a lot of things, but to be free, but then not until you fully became accountable to yourself and to comprehend it, then it started to work.
Yeah,
Once
yeah. I
once
was
you
told,
actually comprehended it and were able to apply it, in the way it's supposed to be.
Which is why we're so big on comprehension.
yeah. So I
Tice says something powerful to support what Marcel said. He says, I thought victories would fix that, but
yeah,
it doesn't with a spouse that's scared. Not only just a spouse that's scared, guys, there are
family too.
people who have been winning and they're nobody, brother, sister, roommate, mother, father, they don't care nothing about the wins. And it is a newbie, and I will also say ego issue,
Mm-hmm.
right?
Word.
That we believe that we're just gonna flex on our family with all our freedom, and they're
Yep.
gonna be like, "Ooh, I want some of that."
Right now, they don't.
They
Most of
sure don't. Hey, but look, check it out, Marcel.
yeah.
Aren't you thankful that I was an asshole brother?
Listen,
Yelling
Asshole,
yelling in the hearing. Don't think we missed
asshole,
that part.
brother, asshole,
I'm
brother.
cool. Listen, when I say I'm cool, like I turned 50 and
I
I
thought
was
Marcel was gonna report the whole group. They doing bullshit over there. Charles, he called himself McReal, okay?
I know, right?
Seven.
No,
His name is Hassan.
And
right?
he just
No,
yelled at the judge in a
Malika.
Zoom hearing.
yeah, no,
Malika.
I was cool. I was like, I'm not going. Like, I got all that. I got all the gook out because I always say to guys in my office, when do people catch fire? And they like, I don't know when the gook is out. Like, you could be smoldering, but you're not gonna catch fire in anything until the gook is out. That's what you got to get all the wet nasty stuff out. And I feel like I've been purging
Wow.
last year to catch fire on, like, there's a piece I'm having on, like,
Wow. That's amazing.
And
yeah.
Marcel, it's okay to cry, man.
Oh
it's
yeah,
We're
I
all
not
on here
here,
crying. There are
not
people in the
yeah. I
chat
mean,
saying they're crying.
yeah, yeah, yeah. I'm cool. So, but in that time, like I said, I lost 200 pounds. You know, it's just yeah. I so much I want to say that I'm just because it's on the thing too. You know, so but I'm happy and
Good.
really really happy. Like even my family now, my mom is like, they're dealing with this. Call Marcel. You know, they dealing with this. And the old me would have had my chest out, my medallion, and freaked him out. But now I'm just like, I was send me what he has. I don't know if I can help him. And it's like, yeah, he's losing his mind and he's losing his memory from Alzheimer's, but he needs to transfer this. I'm like, oh, I get it over to him in an hour. And they like, my mom's like, an hour? And they like, I'm in my mind, I'm like, that's easy. That's like y'all talk about
Light
that's
work,
why they
mom.
work. You know, they're like, well, we'll send you. I'm like, whatever you want to say. But in my mind, but if I didn't go through these steps, all that stuff would have been like the attorneys, the attorney sent this. I'm like, 30 minutes. Like that just helped me see I'm gonna be less time. So yeah, I'm just as a businessman, I'm excited where I'm going in the next 10 years. So
Awesome.
yeah, I'm sorry. I can't I was doing
I
mute
love
up.
the way you think, Marcel. He's like the next 10 years, that long term. That's what's up.
So you still singing?
I'm mastering the last album, and so I wrote, and I got a new album I'm writing. I got like three lawful living songs that nobody will know but love. Like if you hear them, it's
What? Hey,
like I've
somebody said
never
they
written.
stopped drinking in the comments. I'm gonna sip some water to that.
Yo, I'm telling you, this thing is. I'm looking at
40
Malika.
pounds down. I see you, friend.
Word, see. So it's just because the anxiety, most of the stress and habits and all that stuff, it's from the fear of man. It's just, and then you go to church and you talk about being fearless and you talk all this stuff till it's time to like,
Yeah.
and I'm like myself, Jesus was in the temple at 12,
Everybody gives freedom lip service until it's time to do freedom shit.
everybody. I'm like, yo, Jesus was in the temple at 12 learning the law. Like most of the guys that walk with God also studied the law. So they knew when man was doing something foul. You know, and like you can't do that. But if
Word.
when you don't know the law, somebody and guys in my church was like, "Well, bro, the Bible says you gotta uphold the law." I said, "Yeah, I agree.
Yeah. Do you know it?
I agree."
Do you know
So
the
they're
law?
like, "What do you mean?" And I'm like, "They're like, that's." I'm like, "That's a statute. That's not the law." And they're like, "Bro, this," and I'm like, "That's not the law." And they like, I'm like, "This is the law." They're like, "For real?" I'm like, "Bro," and I in my mind, I'm like, "I don't want to have this con. I got stuff to do." But
Myself, you're going to be the next Quack Walker.
the what?
The next Quack Walker. He was the first free man. He sued when Sam Adams said all men are created, were born free and equal. He said, well, wait a minute. Why am I not free and equal? And the court said, yep, it doesn't jive with slavery. You're free. And then for the white people, the white yeoman farmers, they were into peonage until the next war and the anti peonage acts. So he was the first free man.
My
Respect.
Quack
suit.
Quack Walker.
Respect. Well, I think the lady Kate Shaylee or something is waiting.
Yes. Keisha Lee.
Yes.
Hey, it's Keisha Lee. Yeah. So I was gonna
Peace.
just say what Marcel was saying resonated a lot because I don't know if everyone on the call remembers when we had the win with CPS. Our entire family was trying to like convince me to like just bring my son into the building, and like it really like was an eye opener for me as a parent. Just like how blindly and how quick like people we thought were close to us just blindly trusted the system and was willing to like try to
Was it
convince us.
trust or was it fear?
It was fear more so.
They
And
fear what will happen if they express their distrust.
right.
Go ahead.
Yeah, so I was gonna say, I just started like tuning into the Feed the Fam classes, and like I've been like starting it over just to make sure like I'm comprehending it right. And I just wanted to know if there was anyone on the call who has exercised this in real time.
Many of us have, and I'm dealing with it right now.
Okay. And then I just had one more question about CPS. Um, I know Puerto Rico is like a U.S. territory, but to serve CPS or ACS out there, would we go through the same process as we do out here in the States?
For what? A court claim
I had a
or?
mom. Yeah, I had a mom reach out to me. Her children were removed from the home by CPS.
Yeah, but
And she,
whoever did it, whatever agency, location, I'm sure have their address, phone
right,
number. They're not typically hiding.
right.
So you would handle it the same way because it's the same principle.
Okay.
To add to that, when it comes to the energy of assisting people, you must make sure you're not drained, for one. Then when it comes to Puerto Rico, I think I know exactly who you're talking about. 5 children, fathers from
Yeah.
Florida type energy.
Yeah.
Yeah, I already know what you're talking about.
Do
Again,
I know who she's talking about?
I think sort of kinda because there was something done maybe a month and a half ago online, and the suggestion was to, and I get it, people may think, they have all the finances for every other means and forms of energy, but when it comes to this law space, they want to penny pinch or not come up with what's needed for a session. So
So
again,
they send people to ask her a question?
that's what's happening now. Not knocking Kishali of that. However, it's already been said what needs to happen and what needs to be done. It's already been looked up. I think even Freedom had looked some things up not too long ago. If he's still there
Okay.
on TikTok, he knows too. We all went to in some way, shape, or form to get something to be like, hey, look, yo, check this out. Maybe go study that, read that. You might got to put that together.
Freedom
Yeah,
says,
she's
I
like
have.
coming all over my feed.
Yeah, Freedom says, I have. So he knows who you're talking about too.
Exactly. We all know who she's
Yes,
talking about.
Okay.
Okay.
we tried to help her.
Did they try?
We it was to the point where I even
Try,
was
right, Seven?
in the law library. Yeah, that was, who was that?
But
Veronica
sometimes it's
or
not
Miss Credit
about
Pro?
them trying.
That's Miss Credit Pro.
There are people who it actually goes to
Yes, it's
what
Mrs.
Marcel
Credit Pro.
said.
Okay,
It
got
just
you.
goes to what Marcel said. I might be Neo, right? I am the one, but I don't I want to you not to just help me do it.
And that right there is
Okay?
what
And a
can make
lot of
you
people,
convert
especially
on
when they're
anyone.
unwilling to compensate financially, they don't want to say I want you to do it for me because that would make it obvious. Well, shit. I'm not the damn attorney. But if you want to go hire one to not help you, you can do that. There's some people who
Yeah.
seem to prefer that.
Yeah,
So much.
none of it's going to work no matter who's helping you unless you are willing to comprehend it fully to what's going
Listen,
Right.
on.
this is the cheap. I spent 300,000 on attorneys in 5.5, 6 years. Almost lost my house 5 times. This is the cheapest thing you're gonna. I lost my retirement, my savings, fighting for my children, fighting with attorneys, just draining this stuff. They represent the court. Good luck with that.
Hey, don't put that message out there. Me and Malik about to go up on these numbers. Let me
Hey,
stop.
listen, let me tell you, if Malika is Neo, Hassan is that dude that the dude who put you in the chair, and they like, what's going on? And he's like, he's been going for hours. He's like, Hassan gonna put you in that chair, and you're gonna be like, enough. You're like, are you sure? We could go longer. And it's like, dude, enough.
Just
So
saying.
if it's the
We
cheapest
want to
thing.
make you guys strong,
Oh my God.
not dependent upon us.
Correct.
Obviously, it's not that we're unwilling to assist, but it has to be assistance.
Right. And yeah, I appreciate Hassan saying that because like I don't have the capacity to like hold her hand through it. I just wanted to like possibly lead her in the right
Hey, I
direction.
hold
Like I
hands. Y'all
didn't.
know I be holding hands.
Yeah, I be needing my hand
Where
held,
where's
so it's like
where's Wolf Dollar so he
yeah.
can tell you how I squeezed his hand? I'm holding your hand.
Exactly. Yeah, she already knows what the deal is. And at the end of the day, like I said, there are quite a few friends-in-law who probably thought, and I'm just gonna get it out there right now. If they know, they should just give it to us. See, they're gatekeeping. How they gonna do that to us? They just like them over there. And
How
then when
many people listen to the Asmo Solo series, which is free, and then
correct.
listened to a class and was like, "Damn, she said that shit in Asmo Solo too,"
Absolutely.
which is free.
Yes.
I mean, we definitely gave 30 hours, didn't we? You know what I'm saying? Like, was it not 30 hours?
I'm
Can I say
saying it
something
wasn't
too? I think
nothing else to say. Look, private civilian, know what's up. Bro been here the whole 2 hours.
I just want to say something that might be controversial, but I'm gonna say it anyway. That I'm not sure who this woman is or anything, but I can say from going through it myself, the trauma that this creates, having your children ripped from you, is extremely painful, and it's very hard to cope with life at all. So, in her defense, sometimes we need to have a little extra hand holding and help at these traumatic moments. And I yield. Thank you.
That's why when it comes to Marcel, right, I totally sided with him when I heard his story because I don't think a lot of brothers get to share when they've had their little ones around them for an extended period of time, and then they have not seen those little
They
ones.
get ripped away. It's okay. You can see what it
Correct.
is because
They get
that's
ripped
how it
away
be.
too, and they haven't seen their little ones except maybe through some communication device, but it wasn't for another 2 to maybe 13 and a half years. And I absolutely related to Marcel when that happened because I get it. It happens on both sides, just like the mothers. There's more mothers experiencing child support obligations now because
I'm
you have
sorry, Freedom. We'll redo it. Go ahead,
you have
Savage.
men out here who are abusing the legal process just to get back at some woman that's not doing
That's
what they and,
true.
and that's what the issue is. That's the problem. It's hot. It's hot. And that's what the issue is. That's the problem. So it's on both sides. Both brothers and sisters are dealing with something that is very traumatic. However, at the same time, no one should place burden on anyone with knowledge, and no one with knowledge should take on a burden without there being some type of energy exchange. And that is where we really have to allow ourselves to go, you know what? I need to breathe. I need to put my big boy or big girl pants on. And I need to go at this how it needs to go because my idea and my expectation or what I want to happen is not the way it's going to get resolved. And again, I get it. I'm the asshole. Let me be the bad cop and say the bad cop stuff. However, that's reality.
I
I
also
yield.
want to say that these hazelnuts are excellent.
He's snacking. He's snacking.
That's right. They taste so sweet,
He
and I wish everybody could have a taste. So,
Word.
with that said, we are slightly over time. Thank you, Brothers Hassan, for sharing those last words with us.
Yeah, indeed, sis.
Shout out to everybody who shared today. Whether you asked a question, helped to answer a question, whether in the chat, here on TikTok, I appreciate each and every one of you being here. It is my absolute pleasure to be here. And it's really hard sometimes to make a decision in if I'm going to show up to class or if I'm going to go play outside in the dirt.
Word.
But trust and believe, even when I'm playing in the dirt, I be thinking about how to beat the bar. Okay? And
Word.
how to help my friends-in-law comprehend how to beat the bar. People will say, oh, they know procedure and they've been practicing law for so much longer than me.
Knack.
Yep, ever since.
Don't let that negative self-talk stop you. They are the weakest link and they
Yeah,
are absolutely vulnerable.
yep.
And It is through comprehending how to beat the bar. I mean, even today in a consultation, the 2 documents that we drafted while we were in our live Beat the Bar 2.0 class is exactly what they needed. They took 20 minutes, right, Trader McGade? Almost 30
Yeah,
minutes.
exactly. Yeah, you're right.
Explaining something that at the end, Beat the Bar 2.0.
Wow.
Whoa, unto ye attorneys.
I actually said that on the consultation
Yeah,
today.
you did. You did for real, Malika.
Bam.
For they have hidden, right?
Mm-hmm.
They have hidden. Because why? Just like what happened in McGarvey's case, instead of the judge saying you have 7 days to petition for review, they instead say they have 7 days to get out. Someone saying they did not have the Beat the Bar document, but it's the link is inside of the Beat the Bar 2.0 class. So if you're in the Beat the Bar 2.0 class, you have a link to the documents we went over in the Beat the Bar 2.0 class. So with that said, I'm gonna actually compliment my hazelnuts with some actual breakfast.
And you got a session in like 55 minutes.
I do. You see?
Yes, you do.
Are you gonna be on?
Yeah, I'm gonna be on. Earlier, they had the electricity out because the Habitat for Humanity doing their thing across the street, building these new houses. So we had to be out during the time you were on your session, but it's all good. I'll be here. I'll be
Yes.
on the next one.
All right. Peace, y'all.
Peace.
We will see some of you tomorrow, and then the rest